Oyez, oyez, oyez. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Well, good morning, everyone. Welcome to the 4th Court of Appeals. We have just one case scheduled for argument this morning. And let me first call for announcements. It's the City of San Antonio versus Von Dohlen. Mr. Lane, Mr. Mitchell, welcome to the court. There you are, Mr. Mitchell, you're back. And so are you both ready to proceed? Mr. Lane, are you ready?
Yes, Your Honor.
And Mr. Mitchell, are you ready?
Yes, Your Honor.
Very well. Well, let me just first explain, as you all know, we're conducting these oral arguments on the Zoom platform because of COVID-19. But if there's any, if we lose each other for any reason, please rest assured that the clerk of the court is prepared to gather us back together again, and you will not lose any time. And to comply with the public hearing aspect of court proceedings, we are being shown on YouTube as well. As you both know, you'll have 20 minutes to make your respective arguments, and then Mr. Lane, you'll have 10 minutes for rebuttal on behalf of the city. And so with that, please know that we are ready to proceed, and Mr. Lane, you may proceed.
May it please the court. I'm Neil Lane of Northerners Fulbright, and together with my colleagues, Amy Vidara and Peyton Craig, I represent the city of San Antonio. The plaintiffs brought this case to force the city of San Antonio and two non-parties to enter into a contract to open a fast food outlet at the San Antonio airport, specifically Gate A7. The trial court's order overruling the city's plea to the jurisdiction and denying its motion to dismiss should be reversed because the plaintiffs lack standing to bring suit and the plaintiffs' claims are barred by governmental immunity, which has not been waived. This case arises from a vote of the City Council, the San Antonio City Council, to approve a concession agreement that would govern which vendors would operate at the San Antonio airport and the terms on which they would operate. The proposed concession agreement was between the city and a private party, Paradies, and Paradies in turn proposed sub-concession agreements with other private companies, including Chick-fil-A. The City Council voted to approve the agreement, but subject to an amendment which provided that Chick-fil-A would be removed as a vendor. Two council members were quite outspoken. They made it very clear that they didn't wish the city to be identified with a company whose management had been outspoken opponents of civil and political equality for members of the LGBT community.
Let me ask Mr. Lane, excuse me, and both Mr. Mitchell and Mr. Lane will raise our hands when we want you to stop so we can ask a question.
Yes, Your Honor.
Now, this action took place, as I understand it, in March of 2019, and the statute in issue was adopted in September of 2019. Is that correct?
It became effective in September.
Right, right, exactly. So after the contract, the amended contract was approved by the City Council, what actions have occurred from that date to implement the contract? And more specifically, what actions have taken place after September 1st of 2019, if any, in regards to Chick-fil-A?
Your Honor, there are no, with regard to Chick-fil-A, with regard to the contract, the record is that there have been no actions taken. And as you can imagine, things have kind of completely slowed at the airport at this point. So there is this case is pending, no action has been taken. The status quo remains. To be clear, the city believes that the council vote would not have violated the statute that's been codified as Chapter 2400, even had the vote occurred after the effective date. But that question doesn't need to be reached because of the standing and immunity issues. The requirement to show standing under the Texas Constitution, as Your Honors know, stems from two limitations on subject matter jurisdiction: separation of powers doctrine and the open courts provision. The Texas Constitution. Yes, Justice Alvarez.
Yeah, but 24, and I'm trying to look for it here. 2400, is it 03? Basically says that any person can bring a cause of action with respect to this new statute. doesn't that give them standing?
No, Your Honor. The reality is that the legislature cannot dispense with the constitutional requirement of standing. It is a constitutional requirement. Now, what the legislature can do, yes, Your Honor.
But we have a series of cases that bottom line say that the legislature can determine standing. So what do you say about that?
No, what those cases actually say is that within the constitutional limitations, within the constitutional bounds, the legislature can create standing. And what they actually say is that the legislature can lessen the need for particularized injury. That is, that the plaintiff need not show, they can lessen or eliminate that requirement, that the plaintiff need not show how the violation affected that plaintiff differently from any other member of the public. But the Texas Constitution nonetheless requires an injury for the plaintiff to have standing, an injury flowing from a violation. And the requirements, yes, Your Honor.
Just excuse me for interrupting, but you know,
No.
we know that's typically how most of us, you know, have been trained, that there has to be some injury for the plaintiff to pursue a claim. But as Justice Alvarez points out, there are cases that in fact don't require a specific or an injury to the plaintiff. And just following up with that, I mean, we know the court's role is to follow the Texas legislature's statutes as they're written, maybe not as they're intended, but as they're written. And we know that in other cases, the Texas legislature has said that a person has standing to bring a claim if, you know, they're just a citizen, or they're simply a taxpayer, or you know, hopefully, I mean, in some cases, an aggrieved person. So here, the legislature clearly just wrote any party. That's it, any party. Or I'm sorry, any person, which admittedly is extraordinarily broad. Any person on the planet could bring a claim, it appears. But isn't that our role, to interpret what the legislature wrote?
Within the bounds, oh, sorry, Your Honor, within the bounds of the Constitution. In other words, the requirement for injury is not judge-made. And the Texas Supreme Court has made clear that courts' constitutional jurisdiction cannot be enlarged by statute, and that's Finance Commission versus Norwood. And so what the courts do, if you look at each one of those cases, in the case of the plaintiff may have standing, but they still have to plead some injury flowing from a violation. So when you look at those cases, the cases, the courts don't dispense with the need to show a violation and a concrete injury resulting. So if you look at each one of those cases, for instance, it may be that a permit was issued that would result in the destruction of artifacts that belong to us all. Now, the plaintiff doesn't have to show that it's their artifacts or that they're somehow differently affected than every other member of the public, but they have to show that there is a violation and resulting injury. Even that Bawdy House case, which predates the first pandemic, involved a notorious violation of the public order. There has to be a violation and a resulting injury, even if the plaintiff doesn't have to show particularized injury, how they are particularly affected. Yes, Justice Alvarez.
Mr. Lane, and I hate to, I guess, gear you to another direction. And if we decide the issue on the issue of immunity, we don't have to go to standing. So what I'd like to do is I'd like to look at immunity, if that's okay with you and the other justices.
Absolutely, Your Honor. Okay, so Section 2400-004 says a person who alleges a violation of 2400-002 may sue. For that limited purpose, sovereign or governmental immunity is waived. Now, the plaintiffs concede a number of different things. They concede that the statute, the ordinance itself, did not violate 2400. It couldn't have. It wasn't in effect. They concede that the statute is not retroactive. Okay, the legislature can actually retroactively provide remedies for people who've been harmed in the past. It chose not to do so here. And so they haven't alleged a violation of 2400-002. The only conduct that they have identified in their petition is the vote, which they now concede did not violate the statute and that the statute was not retroactive. Their recourse is the same for every other lawful council action with which they disagree, that is, speak up and vote. And that goes to their ability even to bring this suit.
Let me ask you, Mr. Lane. So irrespective of the pleadings, and I know we're to look at the pleadings initially when we're looking at governmental immunity, but the appellees have argued below and on appeal that it's the implementation of the vote that occurred back in March of 2019. It's the implementation of that and the continuing negotiation, I may be using the wrong words, negotiations and such of that are ongoing with this between the city and the concessionaire at the airport, and that is the continual violation, and that is why there is no governmental immunity. So that's why I asked you a moment ago, what has occurred, if anything, since the enactment of this statute in furthering of that contract?
I'm aware of nothing that has happened, and plaintiffs have not alleged anything has happened. They allege that the status quo presents a violation. In other words, a lawful act at inception has been rendered, that has created a status quo that's somehow unlawful. There was no violation in the first place, so it can't be a continuing violation. The only case they cite for their proposition that somehow there's this continuing violation is City of Laredo versus Laredo Merchants Association. And as this court is aware, that case considered an ordinance that was passed in 2014 banning the use of plastic bags, and the argument that the merchants brought was that it violated a statute that had been on the books for 21 years, since 1993. There was not a question as to whether when the ordinance was passed, the statute not only was in effect, it had been in effect for decades, and the merchants sought to enjoin the ordinance before it went into effect. And it was preempted, the Supreme Court held, on the day the ordinance was passed. And here I want to say, and this is very important, Chapter 2400 is now the law of the state of Texas, and the city of San Antonio, in taking into account every decision it makes, is bound by the law of the state of Texas. And any action from today, from the date of that effective date, is the city must comply with it, and it will comply, and it does comply with it. But what can't be the case is that a vote on a contract before the effective date that was affected. This was not like a ban on plastic bags or something. This was a vote on a contract that was approved subject to one condition based on the concerns of the council people. And so the first point I want to point out is that there's no violation. The second point, that there's no injury, because these plaintiffs not only did they not cite a particularized injury, they can't identify an injury that flows from any violation of the statute, because they can't identify a violation of the statute. But if they could even do both of those things, if they could show that there was an injury, if they could show that there was a violation, there's no redressability. The things that they ask for in their suit are, first, they say, they actually, in addressing redressability, all they say is, well, it's easy enough. But that's not really the case. And the court shouldn't presume that that's the case. They asked the court in the first instance to enjoin the city from putting any shop in the space that would have been occupied by Chick-fil-A. Well, that doesn't redress the supposed injury that they claim. That wouldn't get them a Chick-fil-A sandwich, and it certainly wouldn't get them Chick-fil-A in there. And the Supreme Court has said in Heckman versus Williamson County, if the injunction sought could not possibly remedy the plaintiff's injury, then the plaintiff lacks standing to bring that claim. Moreover, they also say that as another argument for redressability, they say that the court could order the city to install a Chick-fil-A restaurant consistent with the original proposal submitted by Parodies. Well, let's just state right here, the city of San Antonio it wouldn't be lawful for the city of San Antonio to install a Chick-fil-A itself. And for that relief to be legal, it would require a contract between two non-parties, Parodies and Chick-fil-A, and neither Parodies or Chick-fil-A are parties. Parodies was originally a party. The plaintiff sued them, perhaps recognizing that it was essential to the relief they sought, but they non-suited their claim. Chick-fil-A was never a party, which is very telling, because if there was anyone who was allegedly injured, you would have thought it might have been Chick-fil-A. Apparently, they didn't think so. The court doesn't have the power to order two private entities who are not parties to a suit to enter into a contract together. Moreover, that order might strongly be resisted. The reason we're all remote is because of a pandemic that's affected us all, okay? By some measures, the court can take judicial notice that air travel has dropped by 75%. And for all we know, because it isn't a party, Chick-fil-A might not feel inclined to open a location in any airport in the United States or the world for that matter right now. And so the redressability requirement goes to the function of and the limitations on the courts. Courts are constitutionally bound to redress harms, not second guess co-equal branches decisions, such as the selection of airport vendors. No redressability means no standing. So we can try to find a violation. There is none. They've conceded. We can try to find an injury. There is none. They want to say, the plaintiffs want to say, that the legislature can dispense with any requirement for injury whatsoever. But when you look at the cases, what you're going to find is that the courts, the courts dispense with the requirement for particularity yes, Your Honor.
Mr. Lane, so if I understand what you're saying, because the City Council approved the concession agreement with the amendment before, and when it did that, it was authorized to do that, it was legal to do what it did, that going forward after September 1, when the statute took place or was effective, that the performance under that agreement is not a violation of the statute. Is that your position?
No action that the city takes after the effective date is a violation unless the city has taken action to punish someone for their affiliation or membership in a religious organization. And so any decisions after the fact, now we know that there are many statutes which have provided remedies and have prohibited conduct. And the whole reason that they're passed is to change the way people behave, presumably. But we cannot go back in time and remake the world unless the statute provides that we can, provides retroactive effect. We can't go back and remake the world as it was before the statute was passed. And so here, the city is going to have a palette of options, not just in choosing this vendor and choosing any vendor. If it's a falafel stand that might go into another city-owned property, if it's some other vendor who's being considered for some other position, the city by law cannot punish someone for their affiliation with, membership in, or support of a religious organization. And the city will abide by that law. And there's no allegation that the city has engaged in any conduct after the effective date of this statute, which violates the statute. And that's the reason. Yes, Your Honor.
Let me see if I understand, though. That's one argument. The other argument that you've made is that we can't go back and redo the contract, correct?
You can't order, this court cannot compel two parties who are not before the court to enter into a contract with each other, whether they want to or not. They can't be ordered to do that.
And here we have a contract with a different provider than Chick-fil-A, and that was entered into through the amendment, I believe, to the concession.
No.
So, go on.
No, Your Honor, what happened was the concession agreement was approved subject to the requirement that Chick-fil-A, that sub-concession agreement, would not be approved.
Yeah, and I
So
understand.
everyone else is approved, but there's no one that's been approved to take its place.
Yeah, and I understand that. And the cases that you cite in your brief from the City of Austin, Texas Education Agency, HIT, and then there's another series of cases. We got them here. Creekmore, Mata, and then the other one is Texas Logos versus Texas Department of Transportation. Those cases stand for the proposition that even if the contract was awarded illegally, okay, was awarded by the governmental entity, and one of them was a bid, two of them were bid process that were violated. You can't sue the government or any of its officers to retroactively void the contract. So how does that apply to this case?
Well, I would suggest, Your Honor, that that's exactly what the plaintiffs are attempting to do. And I think the Austin case is particularly helpful on that point. Although they say they're not trying to apply the statute retroactively, what is the remedy that they actually say that they want? They say, we want the city to enter into a contract on exactly the same terms that it rejected in March of 2019. There's no other way to read that requested relief than to say, retroactively, we want to remake this contract, even though the statute is not retroactive.
So even if the city council violated 2400 for whatever reason, I guess what I'm trying to say is, if the legislature comes back and says, hey, this statute applies retroactively, and it does apply retroactively, based on all these cases, it really doesn't matter, does it? Because the whole purpose is to void a contract, whether it was entered illegally or not. Am I understanding these cases correctly?
Well, I do not disagree with you, Your Honor. I guess the thing I would say in this particular case is everyone agrees that this isn't a retroactive statute, and maybe the legislature could pass a statute that would say anybody who's been deprived, on this basis in the past, they can go back, they have a remedy or something like that. That's not occurred here. And then the question will be, whether it's a little bit different situation, because a retroactively remedial type statute is different from a case that says it's a violation, it was a violation. So.
All right, Mr. Lane, thank you. You have run out of time, but you'll have 10 minutes for rebuttal.
Thank you, Your Honor.
All right, Mr. Mitchell, you'll have 20 minutes. And you may proceed.
Thank you, Your Honors. May it please the court. The district court correctly denied the city's plea to the jurisdiction and its motion to dismiss. There is no possible basis for governmental immunity because Section 2400.004 explicitly waives the city's immunity from suit. And the plaintiffs have standing for two separate and distinct reasons. First, each of the plaintiffs has statutory standing because Section 2400.004 authorizes lawsuits by any person who alleges a violation of the statute without any need to allege or show a particularized injury. And the law of Texas is clear that the legislature may confer statutory standing broadly upon any citizen or any person who alleges a violation of the law. It's no different from the key tam relator actions authorized by the Texas Medicaid Fraud Prevention Act. And it's no different from the citizen suit regimes that were authorized and upheld in Spence, Scott, and Grossman. Second, even if the plaintiffs were needed to allege a particularized injury, They have done so because each of them has stated in sworn affidavits that they use the San Antonio airport for travel and would patronize Chick-fil-A at the airport if the city had not banned it from operating there. And the city tries to get around all of this by claiming that we never actually alleged a violation of section 2400.002. But of course we did. It's right there on the very first page of our petition, on page 5 of the clerk's record, where we cite section 2400.002, and we say, quote, "The city of San Antonio is violating this statutory command by excluding Chick-fil-A from the San Antonio airport on account of its donations to Christian organizations, such as the Salvation Army and the Fellowship of Christian Athletes."
All right, Mr. Mitchell, excuse me. I want to stop you right there because I wanted to ask you, if we all agree that there was no violation at the time that the city entered into this contract or the amended contract or approved the amended contract back in March of 2019, because this statute didn't exist yet, what specific actions have been taken since the date of implementation of this statute, since September 1st of 2019? What specific actions has the city taken? And it has to be adverse action against Chick-fil-A. So what adverse action has taken place since that date against Chick-fil-A?
We have not pleaded specific actions that have been taken post September 1st in our pleadings, because we filed the lawsuit on September 5th. So at the time, we were not aware of the specific actions, but we allege in the petition that the city is taking actions and will take actions in the future to implement the Trevino Amendment. And it's undisputed in this case that the city intends to implement the commands of the Trevino Amendment.
Well, you had your hearing on the plea to the jurisdiction in, I believe it was January of this year. And the record reflects that there was counsel's arguments that were made before Judge Canales, but I didn't see that any evidence was admitted. And so I just would like to know what evidence, and because maybe I missed it in an affidavit or whatever, that has been submitted that establishes an adverse action taken against Chick-fil-A at the time of the hearing.
So at the time of the hearing, again, we had not pleaded that in our petition because we're not required to plead at that level of specificity. Texas is a notice pleading regime. And Mr. Lane has not ever alleged in this lawsuit that we failed to provide fair notice under Rule 47A. But Your Honor's question, I'm sorry.
Well, and I've moved away from the pleadings then and to the evidence that certainly can be admitted at any hearing on a plea to the jurisdiction. And so I realized that September 5th was just shortly after the enactment of the statute, but by January of 2020, when you had the hearing, was there any evidence presented to Judge Canales about any adverse action?
No, and the reason for that, Your Honor, is first, we haven't taken any discovery. Right, so we haven't had an opportunity to develop the factual record on what actions the city has taken post September 1st or what actions the city intends to take in the future. But we have alleged in our petition that they will be taking adverse actions to implement the Trevino Amendment. And that allegation has to be assumed true at this stage of the proceedings on a Rule 91A motion to dismiss. We assume the plaintiff's allegations to be true. What Mr. Lane is complaining about is that we didn't allege with specificity in our pleading what those exact actions were. And the reason for that is we filed the petition only 5 days after the statute took effect. But the other reason is we're seeking to enjoin future actions that haven't occurred yet, but will be occurring because the city intends to implement the Trevino Amendment and the city intends to replace Chick-fil-A with another vendor. They have to undertake actions in order to do that. Yes,
Mr. Mitchell, in order for us to determine whether the plaintiffs have jurisdiction and whether the court made the right decision, we have to begin with the pleadings. And one of the things that the court can look to or should look to as well as part of your pleadings is the relief that you're asking. And the relief that is in the petition is a request for a temporary or permanent injunction that prevents the city and Paradis from excluding Chick-fil-A.
Right.
And also an injunction that compels the city and Paradis to install Chick-fil-A in the airport. So the relief you are asking goes, do you agree, goes beyond just implementing what the city has already agreed to with the amendment? And essentially, you're asking them to go back and, I think, nullify the amended concession agreement and go with the original. Do you agree with me that that's what your relief suggests?
What we're asking for in our relief is for a remedy that will stop the city from violating section 2400.002 and that will undo any violations of the statute that occurred after September 1st, 2019.
And we know from other cases that the legislature has been specific in the remedies afforded whenever there's a violation of statute. For example, it will allow voiding a contract or, but in this case, the statute does not expressly allow for that, does it?
Well, what the statute authorizes is declaratory relief, injunctive relief, and costs and attorney's fees. And what the proper scope of injunctive relief should be is a question for the court to address at the remedy stage. Right now, this appeal is on the denial of a plea to the jurisdiction. And the questions before this court are the governmental immunity question and the question of standing. What remedies we should get if we do prevail in this lawsuit at the end is a question, I think, really for the district court to consider at the remedial stage and then for this court to review if a remedy is awarded. But we certainly have standing to seek some relief. And that's all we need to do to survive Mr. Lane's plea to the jurisdiction. We don't have to show that we ultimately will prevail at the end of this litigation. All we have to show is that governmental immunity has been waived, and it clearly has been waived because the statute is explicit on this point. And second, we just need to show that we have standing to ask for the relief that we're trying to obtain. We're not saying that we actually will obtain it, perhaps. That comes later, after discovery, after evidence, after arguments, after the judge considers arguments for and against particular remedies that we're seeking. But we certainly can get into the courtroom door. Yes?
And assume with me that the relief requested asks for retroactive relief. Just assume with me. Would you agree that then governmental immunity is implicated?
It depends on what Your Honor means by retroactive relief. We can seek retroactive relief if we're trying to remedy actions that occurred after September 1st, 2019. So it would be retroactive relative to today.
And that's very good. Retroactive, and I would like to use September 1 as the date.
We cannot, we cannot, in our view, we cannot use this statute to cancel or undo or seek any judicial redress for actions the city took prior to September 1st, 2019, because the statute is not retroactive. It did not. Yes.
But isn't that the ultimate effect of the relief that you're requesting in your prayer for relief? It would, in effect, require the city of San Antonio to negotiate and enter into a contract with Paradis and with Chick-fil-A as a sub-concessionaire. And I mean, it seems to me that that's really what your prayer for relief is seeking, is to put them back to that date. And in effect, that would be requiring an undo, if you will, or a nullification of the contract that was signed, and put us in a situation, or put the parties in a situation where the city has to renegotiate with Chick-fil-A, and we don't have Chick-fil-A here. I mean, they may not want to. Yeah. And we just don't know that. That would be speculation. So it seems to me that in accordance with the two or three cases that Justice Alvarez had mentioned, and more specifically the one from Austin, that is what your relief seeks.
Well, we are not seeking any relief that would require the city council to repeal the Trevino Amendment, or any relief from this court that would formally revoke the Trevino Amendment in any way. Courts can't order legislatures or city councils to repeal statutes or ordinances in any event, even when they find the statute or ordinance to be unconstitutional. What they can do is enjoin city officials from taking actions to implement the allegedly unlawful or unconstitutional enactment. Now, the Trevino Amendment was lawful when it was enacted because the statute had not yet been passed. But any action the city takes after September 1st to implement the instructions of the Trevino Amendment are a violation of section 2400.002. And those are the actions we're seeking to enjoin and undo. Justice Alvarez?
Isn't that a little bit of speculation to enjoin a governmental entity or try to enjoin a governmental entity for things that have not happened? Go on.
This happens all the time. Anytime a litigant sues to enjoin the enforcement of a statute that he believes to be unconstitutional, he's seeking to enjoin a future action of a governmental official that's authorized by statute that they haven't yet taken. And anytime this is.
But this is a little bit different because we're not alleging, or no one is alleging, that the 2400 series is unconstitutional. What I'm trying to figure out is if nothing has happened with respect to Chick-fil-A, and nothing has happened with any violations on the part of the city of San Antonio from September 1st onward, your suit is trying to, I mean, you don't know if they're going to violate it. You don't know if they're going to do it. Isn't it a little bit premature to I guess that they're, or speculate that they're going to violate the statute? And if it is premature, how do you have standing?
I don't think it's premature at all. And I don't see any speculation here, Your Honor, with all respect, because the ordinance commands the city officials to replace Chick-fil-A with another vendor. It's right there in the ordinance, and city officials have to obey the ordinance. And that command in the ordinance conflicts with the statutory command in 2400.002. To the extent they're taking, I'm sorry.
But they are obeying it so far because there hasn't been another violation. So
we don't know that, Your Honor. I mean, we don't know that because they may have been negotiating with any action they take. The definition of action is extremely broad. Any adverse action to exclude someone from a property that's based even in part on their contributions to a religious organization. If they're picking up the phone to negotiate with a replacement vendor, that's an action under this.
But isn't that something that you're going to have to do through discovery once you have to have at least an allegation that they violated it, and then through discovery you do that. And we're not in that phase right now. We're in jurisdiction, so we have to say, okay, based on, for jurisdictional purposes, for immunity purposes, have they violated it? And there's no allegation of that, at least no allegation. So I'm thinking it's speculative, it's premature. Is it ripe? Is the cause of action ripe? And that's where I'm going.
Yeah, absolutely it's right, Your Honor, because there's an ordinance in effect right now that commands the city and its officials to replace Chick-fil-A with a different vendor in that space apart from gate A6 in the airport. So it is right. We don't need to show a past violation at this point because we're simply here on a motion to dismiss under Rule 91A. We're at the pleading stage of litigation. All we need is an allegation that allows us to get to discovery. When we get to discovery, we'll find out exactly what the city has done and what the city intends to do to implement the Trevino Amendment. Chief Justice? Yes.
Yes. Does the record show whether or not there is a vendor currently in the location that was formerly going to be Chick-fil-A's?
No, the record does not show that. Again, we haven't taken any discovery yet at all.
So if that space is filled by someone else, by another vendor, and I don't know, and as a court, we can't know if it's not in the record, but wouldn't that also be speculation? It seems to me you're asking to compel the city to put Chick-fil-A in that spot because by not doing it, they are violating the statute. But if there's already someone in that spot, and Chick-fil-A is not asking for it, it seems like there's no redressability. You would be undoing a contract that's already been signed and done and was done lawfully before the date of the enactment.
Oh, if the contract was done lawfully before the date of September 1st, I agree, Your Honor, that could be a serious problem because the contract would be lawful at the time it was enacted. But the city does not allege that they have entered into a contract with another vendor. And as far as I know, and again, none of this is in the record, as far as I know, they have not entered into a new contract with a replacement vendor for Chick-fil-A. If they enter into that contract after September 1st, 2019, the contract is illegal. And the replacement vendor who signed the contract would have known that because they could read the statute, they would have known of our pending lawsuit, and they would know that any action taken by the city to exclude Chick-fil-A based on its contribution to a religious organization is in violation of state law. And we have the right to seek, I'm sorry.
Well, is that Parodies? Is that who you're speaking of when you just mentioned the contract being entered into?
No, there's a contract currently between Parodies and the city of San Antonio.
Right.
And the actual language of that contract requires a Chick-fil-A restaurant to be installed. They passed an amendment when they ratified the ordinance, when they ratified the contract. They passed the Trevino Amendment that instructed the city to work with Parodies Lagardère to find a replacement vendor for Chick-fil-A. But as far as I know, no contract has been entered into between Parodies and the replacement vendor, and no contract has been entered into between the city and Parodies or the replacement vendor with respect to who's going to take that space. If the contract postdates September 1st, I see no problem at all in a remedy that undoes the contract because the contract violated state law at the time. If the contract was entered into before September 1st, I agree with Your Honors that that could be a very serious question, whether we could seek a remedy to undo that type of a contract. But again, all this comes later when we've taken discovery, and it's a question really for the district court to address at the remedial stage of this litigation if we get that far. Right now, we're still at the pleading stage.
Mr. Mitchell?
Yes.
So you've just expressed to us that you don't know whether there have been other contracts entered into. And we've got to make a determination based on what's part of the record on appeal. Mm-hmm. And we don't have any information on that. And you've indicated, and I agree with you, that if there is a contract that has already been entered into with someone else prior to September 1, that's a problem. But whose burden is it to provide a complete record for us to be able to consider that? Would that be your burden as the prevailing party at the trial court level?
Well, again, at this stage of the litigation, we haven't had any discovery yet. So there's not going to be any of this material in the record. All that the court has to go on right now is the allegations of our complaint. Do the allegations of our complaint sufficiently allege standing? Are the allegations of our complaint sufficient to overcome governmental immunity? That's the only issue for this court to resolve at this stage. It's quite possible that after discovery and after evidence is introduced and after we've moved for summary judgment, there could be evidence that shows that our clients may not be entitled to all of the remedial relief that we're seeking. But none of that is relevant at this point. Yes, Chief Justice.
Isn't it the plaintiff's burden to establish that the court has jurisdiction to hear the claim? And that's to me an important bit of information, is because we know when the amendment was voted on, and perhaps there was another contract that was signed before September 1st. And it seems to me that would have been your burden to find out before your hearing in January.
I see my time has expired. May I answer?
Yes, please.
We have satisfied that burden, Chief Justice Marion, because we have put in the record the text of the ordinance, the text of the Trevino Amendment, which explicitly commands the city and its officials to replace Chick-fil-A with another vendor. That is an ordinance that is directing city officials to violate section 2400.002 of the statute. And we have come into court alleging that the city will be taking actions in the future to implement the Trevino Amendment. The city does not deny that they will be taking actions in the future to implement the Trevino Amendment. And that's all we need to allege. It's undisputed at this point that the city intends to take those actions in the future. And we can seek judicial relief to stop the city from taking actions to violate state law. And I see my time's expired.
Thank you. Any other questions?
No.
Well, thank you very much.
Thank you, Your Honors.
Mr. Lane, you'll have 10 minutes for rebuttal.
Yes, thank you, Your Honor. Well, I think the court has a good feel for the scope of the plaintiff's expansion of jurisdiction, in this case, beyond the constitutional bounds. Plaintiff says, no matter what the pleadings say, okay, the plaintiffs have conceded, and even conceded again today, that the act at the time that it was taken, the ordinance in March of 2019, wasn't a violation. The statute is not retroactive, and yet somehow counsel says that they can proceed with this lawsuit. And I wrote down what counsel said for the plaintiffs. Quote, "It's too soon to know what the city will do wrong." As if the role of this court is to set up a commission of plaintiffs to kind of oversee and compete with the decision making of the city. Allowing this standing in this circumstance would open the floodgates to plaintiffs who really, what he's saying is, I didn't have to even allege what the city said or did. I didn't have to allege that my client was a supporter of these various organizations or took these positions. All I have to do is allege a violation of the statute, and I have standing. And gosh, you know, I get discovery from that point on. That is not the case. This court has a requirement that is limited to cases that have standing and where there's no governmental immunity barring the suit. It cannot be that any disgruntled vendor can say this. I do not agree, and the city does not agree, that any contract going forward, and let's not just say in the space where Chick-fil-A is, could be any space. Who knows what the configuration ultimately will be after this pandemic is over. But that, for instance, if the city is presented or its staff has presented options between, let's say, I'll just pick three of my favorites: Green Vegetarian Restaurant, Jerusalem Grill, and Rudy's Barbecue, and they select one, that is not in and of itself a violation if they're not taking an action to punish someone for their affiliation with, membership in, or support of a religious organization. Now they're going to be told in any action after September 3rd, they have to comply with the law, and the court can't presume that they're going to violate the law. He brought up, plaintiffs again brought up this notion that they have this sandwich grievance. And they say that even that trifle, that they don't have the sandwich they want, is enough to support standing and support a waiver of the sovereign immunity. But in fact, Chick-fil-A has never been offered at the airport since it opened for business to commercial traffic after World War II. The fact that they can't get a sandwich today is the result of lawful decisions made over the course of about 70 years, okay? And so they're not injured by the lack of an option that they want. That is not an injury that's related to a violation of the law. They don't allege that any of those decisions that resulted in the mix of vendors was in any way unlawful. Now let's talk about redressability for a moment. The plaintiffs are bound by the remedy they seek. They can't get up here and say, well, I know we said that we want to enjoin them from putting anything in the space, and I know that we said we want to have the court order two non-parties to enter into an agreement. And let's be clear, the only way Chick-fil-A or any other vendor comes in to that airport is they enter into a sub-concession agreement with Parodies, which is the concessionaire. So you can't gloss over the fact that there is a separate contract between two non-parties that they're seeking this court to order. And it's beyond the jurisdiction of the court to order non-parties to enter into commercial arrangements. Again, if they even want to, there's good reason to believe they might resist that heartily at this point, given the circumstances. Now, with respect to governmental immunity, I don't need to remind, we're on Zoom today. I don't need to remind the court that we're in the midst of a pandemic and that resources are stretched. And for that reason, that is why the court the state jealously guards its sovereign and governmental immunity and only allows it when it determines to do so, and why the courts have time and again and have determined that it should be strictly construed any waiver. In this case, where the plaintiffs have alleged that the city engaged in a lawful act and has not engaged in an unlawful act since, but they want to have a lawsuit on file so that they can sit and wait and maybe figure out someday a theory on which a subsequent contract is unlawful. That does not satisfy the constitutional requirement for standing. I would suggest that the statute itself did not contemplate that it contemplated that a person would be trying to remedy an actual injury, not trying to police the selection of vendors for the airport, of San Antonio. And so in that regard, I would say again, no injury or no violation that's actually identified by any conduct. And it shouldn't be presumed to occur in the future. Secondly, no injury that they've suffered or anyone else that they can identify. And thirdly, it's just impossible to redress this injury by means of this lawsuit. It is not enough to simply allege a violation. The plaintiff has a burden to establish that this court has jurisdiction and that the suit may proceed based on a waiver of governmental immunity. Unless the court has any questions for me, I conclude my presentation and hope everyone remains safe and healthy.
Well, thank you very much, Mr. Lane, and Mr. Mitchell, thank you both for your excellent arguments. The case has been submitted and court is in recess. Thank you.
Thank you, guys.